Welcome to Do It for the Case Law on Tuesday, July 21st, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. We are covering 98 cases across 11 circuits today. James Taylor is reporting on criminal justice, including drug trafficking and firearms. Aisha Johnson covers civil rights, including Section 1983 and employment discrimination. Michael Reeves brings you Supreme Court and constitutional law along with habeas corpus. Maria Santos handles business, labor, and civil matters like contracts and securities. And Patel reports on immigration and government cases, including administrative agency review. Please subscribe to the show for daily updates. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 29 criminal justice cases today across the federal circuits. 16 affirmed, 3 dismissed, and 10 reversed, vacated, remanded, or split outcomes. Starting in the 10th Circuit, a sentence was vacated and remanded for resentencing because the district court violated Rule 32 of the Federal Rules of Criminal Procedure by failing to verify the defendant read the presentence investigation report despite his express statement that he had not reviewed it with counsel. Moving to the 4th Circuit, 6 cases were affirmed, including Santillan, Barker, Perez, Cart, Wilson, and a grouped filing. 2 outcomes were split. Jones had a money laundering conviction vacated for insufficient evidence of an agreement to use gun proceeds for further trafficking, and Chen had international promotion money laundering reversed while fraud conviction stood. The 5th Circuit dismissed 2 appeals on Anders' briefs, finding no non-frivolous issues in Blanchard and Ledesma cases. Palomares saw his felon in possession charge reinstated as alien smuggling is inherently dangerous under the Second Amendment after Bruin. The Fullerton PPP fraud appeal was affirmed with sentencing enhancements for sophisticated means and money laundering upheld, though remanded for a clerical correction to one judgment. 2 Odu appeals were affirmed regarding guilty plea sufficiency and sentencing calculations. In the 6th Circuit, Demiers's drug conspiracy sentence was affirmed based on co-conspirator testimony and FedEx records, while Risper's felon in possession conviction stood after a lawful traffic stop. The 7th Circuit affirmed Mendoza-Rubio's role enhancement for money laundering but vacated Bridges' sentence because the district court failed to make specific factual findings for the guideline application beyond a reasonable doubt. The 8th Circuit dismissed Clemens's appeal due to an effective plea waiver, affirmed Whiting's denial of compassionate release citing Rutherford, upheld Mason's firearm conviction with drug trafficking evidence, and affirmed Good's supervised release revocation. In the 9th Circuit, Ford's felon in possession conviction was affirmed despite outrageous government conduct claims, while Kolar's Paycheck Protection Program fraud convictions were vacated and remanded for a new trial due to juror bias that wasn't investigated by the district court. Finally, the D.C. Circuit affirmed Navarro's contempt of Congress conviction, ruling executive privilege must be invoked by the president, and in the consolidated Jones appeal, sex trafficking conviction stood but one defendant's life sentence was vacated for resentencing. Back to you, David.
Thanks, James. Let's turn to Aisha covering civil rights and employment discrimination.
Thanks, David. 26 cases today. 22 were affirmed. 1 was affirmed in part and reversed in part. 2 were reversed and remanded, and 1 was vacated and remanded.
First, the Third Circuit reversed a dismissal of John Doe's Title IX claims against Princeton University, holding that sex discrimination allegations were plausible. The court also vacated class certification in pharmaceutical fraud litigation against GlaxoSmithKline, ruling statistical evidence must prove actual causation rather than correlation. In the 10th Circuit, the court affirmed qualified immunity for Governor Gordon, but reversed dismissal of Dr. Cuban's First Amendment retaliation claim regarding gender-affirming care legislation. The court also affirmed summary judgment in library speech restrictions and police force claims against deputies. Moving to the 4th Circuit, 5 civil rights actions were affirmed, including challenges to medical care conditions, attorney jurisdiction, and prisoner screening dismissals. In the 6th Circuit, 4 cases were affirmed, covering standing for a nurse association, qualified immunity denials in force disputes, and excessive force claims during arrest. The 7th Circuit affirmed summary judgment against journalists injured at protests and police officers who entered a home with consent. In the 8th Circuit, a school district won on disability discrimination claims where deliberate indifference was not proven. Finally, in the 9th Circuit, the court affirmed dismissal of employment claims by former state employees regarding vaccination mandates. It reversed summary judgment for whistleblowers terminated by Arizona officials.
It also upheld discovery sanctions against nail salon owners who deleted electronic records and dismissed a prisoner's civil rights claim under Younger abstention. The court affirmed denial of a preliminary injunction to an educator regarding book display duties. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering the Supreme Court and constitutional law docket.
Thanks, David. I have 9 cases for you today. 8 were dismissed or denied, and 1 was affirmed. In the Fourth Circuit, Luke Patterson v. Warden R. Brown was affirmed. The court upheld the denial of habeas relief, noting in a footnote that while the filing was treated as a Rule 59e motion for reconsideration, it was untimely and should have been a Rule 60 shot. Kristen Tukach Pelgrim's petition for a writ of mandamus was denied. She sought orders for detention review and competency hearings, but the court found no clear right to relief given prior habeas attempts. 7 other appeals were dismissed without oral argument in the Fourth Circuit. This includes Benjamin Moss, Lee Anthony Winston, Mason Whitehide, Reginald Spivey, and Sid Fooley, all of whom failed to obtain a certificate of appealability under Section 2255 of Title 28 for successive habeas motions. Theodore Bolick v. Donnie Stonebreaker was also dismissed because the denial of summary judgment is not a final appealable order. Moving to the Fifth Circuit, Jorge Amado Hernandez Serrato v. Alexander Sanchez was dismissed as moot following his removal from the United States. Back to you, David.
Thanks, Michael. Now let's turn to Maria covering business, labor, and civil.
Thanks, David. I have 14 cases today. 2 reversed, 1 vacated and remanded, 3 remanded, 7 affirmed, and 1 dismissed. Moving to the 10th Circuit, Miller v. CNH Industrial America was reversed, where the court held a tractor manufacturer had no duty to warn operators about dismounting while moving under Kansas law Section 6605C due to the open and obvious danger exception. Jenkins v. Prime Insurance was affirmed on summary judgment for breach of good faith under Utah law. Over in the Fourth Circuit, Thomas v. Maryland was dismissed for lack of jurisdiction because the notice of appeal was filed late under Federal Rule of Appellate Procedure 4A1A. Onanuju v. Virginia Housing was affirmed denying motions to alter or vacate dismissal. Moving to the Fifth Circuit, Tolliver v. Navy Federal Credit Union was affirmed on time-barred FDCPA and fraud claims. In the Ninth Circuit, Amucci v. Mullen was vacated and remanded regarding service deficiencies under Rule 4M. Garcia v. Blanche was remanded on immigration family group social distinction grounds. Fecoaga Ramos v. Blanche was remanded for improper adverse credibility determination. Sacleboutique Street v. City of Santa Barbara was affirmed rejecting regulatory takings claims under Penn Central. Cachet Financial v. Berkeley Insurance was affirmed denying coverage under the fraudulent instructions exclusion. Glenn v. Americo Financial Life was affirmed dismissing standing and COVID guidelines claims. SEC v. Choice Advisors was affirmed upholding remedies for fee-splitting violations under MSRB Rule G42E1D.
Finally, in the D.C. Circuit, Hospital Menonita v. National Labor Relations Board was reversed, finding the successor bar rule inconsistent with the NLRA. Thrivent Financial v. Securities and Exchange Commission was remanded for arbitrary denial of rulemaking petition. Back to you, David.
Thanks, Maria. Let's turn to Raj covering immigration and government.
Thanks, David. Today's immigration and government docket contains 20 cases. The disposition roll-up is 3 affirmed, 4 split outcomes, 2 vacated or remanded, and 11 denied or dismissed. Starting with the Fifth Circuit, ExxonMobil Corporation versus the Occupational Safety and Health Review Commission resulted in a vacation and remand. The court held that the Occupational Safety and Health Act does not grant OSHA authority to mandate recording of mental illnesses under Section 1904.5b subsection 2, Item 9 of the Code of Federal Regulations. Also in the Fifth Circuit, Ignacio Saznava Rodriguez versus Sylvester M. Tree Ortega saw a procedural stay granted pending en banc rehearing, while Andrew Tarver versus the Commissioner of Social Security was affirmed based on substantial evidence supporting the denial of disability benefits. Over in the Ninth Circuit, 4 intervention cases involving the state of California versus automotive and fuel industry groups were affirmed in part and reversed in part regarding motions to intervene as of right under Federal Rule of Civil Procedure 24. Ricardo Avila Garcia versus Todd Blanche was denied on Convention Against Torture grounds due to lack of specific evidence. Moving to the D.C. Circuit, Novartis Pharmaceuticals Corporation versus Robert F. Kennedy Jr. and Titan Consortium versus the Argentine Republic were both affirmed. In environmental cases, Save the Sound versus the Federal Aviation Administration, Beyond Nuclear versus the Nuclear Regulatory Commission, and Public Safety Spectrum Alliance versus the Federal Communications Commission were all denied. In the Fourth Circuit, 3 petitions from Magus Jamiai Rafikul Anand regarding district court delays were denied or dismissed as moot. Lucy Tanto Taku versus Todd Blanche and Peter James Sovula versus Todd Blanche were both denied on immigration review grounds. Finally, in the 11th Circuit, Sherry Jefferson versus the State Bar of Georgia was dismissed for lack of jurisdiction due to an untimely notice of appeal filed 2 days after the deadline. Back to you, David.
That concludes today's broadcast for Tuesday, July 21st, 2026. Thank you to James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel for covering the day's federal appellate opinions. Today's docket featured 2 reversals or remands, 59 affirmances, 16 other dispositions, and 21 dismissals. The most significant outcomes from today include the 2 reversals and remands which deserve attention for their legal reasoning. Several appeals were dismissed on procedural grounds throughout the broadcast. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for more updates.